I call this meeting to order. Welcome to meeting number 41 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to order reference of October 31st, the committee is meeting to begin its study of Bill C9, an act to amend the Judges Act. Today's meeting is taking place in hybrid format pursuant to House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to take a few comments, make a few comments for the benefits of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen, either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raised hand function. The clerk and I will manage the speaking order as best as we can, and we appreciate your patience and understanding in this regard. On our agenda today, we'll be proceeding on the clause by clause of Bill C9, and if the time permits, we will try to continue in camera our progress on our study of the draft report on government's obligations to the victims of crime. Back on our first item of business today, we'll have officials from the Department of Justice with us for any technical questions. I would like to welcome Shakiba Azmi, Counsel, Judicial Affairs Section, Public Law and Legislative Services Sector, and also Patrick Xavier, Acting Deputy Director and Senior Counsel, Judicial Affairs Section, Public Law and Legislative Services Sector. I guess if we're ready to start clause by clause and consideration of C9, I'd like to provide members of the committee with some instructions and a few comments on how committee will proceed for clause by clause for Bill C9. As the name indicates, this is an examination of all clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the bill and in the package each member received from the clerk. Members should note that amendments must be submitted in writing to the clerk of the committee. The chair will go slowly to allow members to follow the proceedings properly. Amendments have been given an alphanumeric number in the top right corner to indicate which party submitted it. Then there's no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. During debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first, then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will vote on the short title, the title, and the bill itself. And if amendments are adopted, an order to reprint the bill may be required so that the House has a proper copy for use at report stage. Finally, the committee will have to order the chair to report the bill to the House. That report contains only the text of any adopted amendments, as well as an indication of any deleted clauses. To begin the clause by clause study, thank you, Mr. Moore. I know we are all pretty well versed in this, but I feel it's still my duty to kind of go through it. The chair calls clause 1. Shall clause 1 carry? Oui. Okay. Shall clause 2 carry? Yes. Shall clause 3 carry? Shall clause 4 carry? Shall clause 5 carry? Shall clause 6 carry? Shall clause 7 carry? Shall clause 8 carry? Shall Clause 9 carry? Shall Clause 10 carry? Shall Clause 11 carry? Clause 12, we have NDP Amendment 1. Shall NDP 1, Mr. Backrack, shall NDP 1 carry? Do you want to speak?
Do you want me to introduce it? I'm happy if you just want to call the vote,
You
but
should introduce it.
perhaps
Sorry,
I
you
should introduce it.
Yep, go ahead and
Thank you,
introduce
Mr. Chair, and thank you to the committee for allowing me to sit in for my colleague, Mr. Garrison. I'll do my best here. NDP 1 is an amendment that Bill C9 in Clause 12 be amended by replacing the line 13 on page 6 with the following. Quote, alleges sexual harassment or that alleges discrimination or improper conduct that is substantially similar to discrimination, end quote. And I believe this was based on a concern brought to the committee by the National Council of Canadian Muslims, which appeared before you as a witness during the consideration of C9. The goal here, if I understand it correctly, is to avoid complaints being summarily dismissed at the screening stage and to ensure that that complaints are heard and investigated through that first stage, increasing public confidence in the process. And I think that's a summary of why that amendment was brought forward. Thank you.
Okay. Mr. Nansingari?
I'm just wondering if we could hear from council on this.
Sure. Would either one of you, Ms. Azmi or Mr. Xavier, want to comment on this?
I'm happy to comment on it. So I think the term substantially similar to discrimination is a bit vague. I mean, it doesn't really have a clear legal meaning. So if something is it's discrimination or it's not, something that is substantially similar to it but not discrimination, exactly what that means and how it could constitute misconduct would seem a bit unclear. So we're not aware of any kind of instrument that would define what constitutes substantially similar to discrimination and how it might constitute misconduct.
Any other debate on this, or Mr. Van Popta?
Just a question to council then. Could we drop the second part of that so that all it reads is alleges sexual harassment or that alleges discrimination?
Well, I think that's already how the clause reads, isn't it? So that alleges sexual harassment or discrimination on a ground prohibited within the meaning of the Canada Human Rights Act. So I think that wouldn't that revert the provision to the original wording?
The question is if it changes the import to drop the phrase that includes the term substantially similar to discrimination.
Yeah, I mean, if that term were dropped, then so long as we retain discrimination on a ground as set out in the Canada Human Rights Act, then that would be fine. That provides a clear legal standard that screening officers can assess complaints against.
Vote on this, Mr. Clerk? No further debate?
I guess my point, Mr. Chair, is that this is not very clear, and I think it will complicate the definition. I think, as council has indicated, it wouldn't give the clarity I think that's required for the intention of the amendment. And certainly, I think overall, in the context of the bill, I think it will render the overall definition to be, I would say, incomplete and would not give the clarity required for the decision maker in this process.
So, do we want to vote, or does
Mr.
it?
Chair?
Mr. Backrack, yeah.
I believe the intention was to avoid an overly prescriptive definition at the very first stage, so that the preliminary investigation could then gain greater clarity in terms of whether it indeed fit the more specific legal definitions that council has indicated. The concern being that if there's a case where it's unclear if it meets the specific definition, that the bill should err on the side of moving those complaints through to the first stage of investigation, as opposed to dismissing them and excluding them from the process based on limited information at that initial pre-investigation stage. I believe that's the intention.
Okay. If no further comments, I guess we go to a vote on it. Mr. Clerk? Recorded vote? No? Doesn't matter. Show of hands. All those in favor? I guess it doesn't. All those opposed? Defeated? NDP motion, NDP Amendment 2. Would you like to introduce it?
Thank you, Mr. Chair. NDP 2 is an amendment that Bill C9 in Clause 12 be amended by adding after line 31 on page 6 the following. If the reviewing member dismisses the complaint, they shall inform the complainant in writing of their decision and the reasons for it. The rationale here was that the complainant be given full and complete information on the reason for the decision, not simply a summary of the reasons and the decision itself.
Any debates or Mr. Nansangari?
Again, I seek some clarity from council on this.
Sure, Mr. Xavier.
So what this amendment seems to do is sort of codify the existing procedural fairness obligation of the council to provide the complainant with notice of the decision and of the reasons for the decision. So that's already a right that complainants have. And so I guess the thinking behind Section 87 of Clause 12, which requires the CJC to set up a policy on how to notify complainants of the outcome of their decisions, the thinking behind that was that the CJC would establish the policy, and then the policy would come under review by the federal courts whenever a complainant applies for judicial review of the council. And so if the policy is found deficient in some way, it could simply be amended and corrected. And so you would have an evergreen document that could evolve with the law on the duty of procedural fairness as owed to complainants. And so that was the thinking. So the federal courts have already been clear that that complainants have this right. So the CJC's policy will have to reflect this right. So whether to codify it in the statute, I think is entirely up, of course, entirely up to this committee. I mean, there's no harm in it. There is the possibility, though, that one thing the committee might consider turning its attention to is the possibility that, as it is, it might. It might be useful to add a caveat that the reasons should not include any personal or confidential information or information that it might not be in the public interest to disclose. And the only reason it might be useful to add a caveat like that is because you'll see that caveat kind of de facto added in other parts of the bill. So where a report of a hearing panel is required to be made public, there's always the possibility of redacting it in accordance with the public interest reasons for issuing a publication ban or for holding hearing in camera, and you know that's just to ensure that confidentiality reasons or public interest reasons for holding hearings in camera or issuing publication bans can be respected in terms of what's issued publicly. So. It might be useful to add a caveat here that personal or confidential information should not be released. It might be useful to note that when the same allegation of misconduct, I think I mentioned this last time I was here, the same allegation of misconduct can provoke a complaint from a wide variety of complainants. So the victim of the misconduct can complain, people who have direct knowledge of the events can complain, and members of the general public who hear about it in the newspaper can complain. And arguably, not all of those complainants are necessarily entitled to the same level of reasons. It depends on the context. So, adding a caveat that personal or confidential information should not be disclosed might be helpful in terms of allowing the CJC to tailor the reasons accordingly.
Thank you, Mr. Moore.
Thanks, Mr. Chair, and thank you for the explanation. I'm inclined to support NDP 2, the amendment, but with the caveat that has been raised by Mr. Xavier. So he provided, I thought, some pretty good language, but I don't think that was a drafting instruction. So maybe, I don't know if we want to come back to it or if we need to work out the exact language now, but I think it's probably important that that language around personal and confidential material be included in the amendment. So a friendly amendment.
You'd have to do. So I've been told that it would have to be submitted in writing, so somebody would have to submit it. We can put it in, we can come back to this one after, if that's something you want to do. A sub-amendment would be done. We'd vote on the sub-amendment, and then we vote on the amendment, and then, yes, Mr. Becker?
I'm just wondering if I can ask through to Mr. Xavier, did I get that correct? Whether the protection of confidential and personal information would be covered under any other statute, or whether, so if it wasn't explicitly included in this clause, are there other statutes that would protect those individuals and their identities?
It's not entirely clear. So I believe the CJC is exempt from access to information and privacy laws. So fortunately I don't have that answer right in front of me. I generally speaking, I think the council is very conscious of confidentiality and has always attempted to protect it wherever possible. It might be able to read that into the provision, but the bill has erred on the side of caution and always indicated in those other provisions, as I said, that confidential and personal information needs to be protected where that's necessary. So to indicate it here would just kind of follow the policy that the bill has established in these other provisions. Another example is 147.3 when financial that report of the financial review is issued every 5 years. Again, there's an exhortation there to protect personal and confidential information. So it's just to err on the side of caution and ensure that information is indeed protected.
So, Mr. Xavier, just to be clear, so without this amendment, the right of individuals to get basically a summary of the information, as well as the policy that you were talking about earlier that governs what kind of information is to be provided, will still be available, right? If I'm correct, and then would this hinder the ability of the policy to evolve as it has evolved over the number of years, or would it give you would there be additional restrictions for you to make sure that the policy is in line with kind of the current practices? Because we're not going to, unlikely to amend this act anytime soon, so we want to have a longer term sight on this.
It seems to codify a very basic right to simply receive reasons for a particular decision, specifically the decision to dismiss complaints by the reviewing member. And so it's hard to see how that would hinder the ability of the policy to evolve. The policy will still there will still need to be a policy that will address the notice of complainants probably in other ways. So it's hard to see how that would hinder evolution of the policy.
So, Mr. Chair, we're inclined to not support this. We feel that there's sufficient safeguards in place, and we will not be supporting this amendment.
I just thought to do justice to my colleague's thinking, I would read the note that he left on this, explaining the rationale. It is difficult for a complainant to know whether there are grounds for asking for judicial review of a dismissal at the screening level or a decision of a review panel without having the full legal reasons for the outcome. Currently, and continuing under C9, complainants only receive the decision and a summary of the reasons from the CJC. Ironically, once the application for judicial review has been filed, the full legal reasons must be disclosed to the complainant. Both logic and transparency seem to demand that the legal reasons be disclosed at the earlier point in the process. And I would note that I believe Professor Craig Scott from Osgoode Hall Law School spoke to this point when he appeared as a witness before the committee. Mr. Garrison goes on to say that as it stands, C9 inadvertently makes the process more secretive as it reduces the number of opportunities for outside review in its attempt to simplify the process and shorten timelines for resolving complaints. So really, these both NDP Amendments 2 and 3 aim to provide more transparency by providing the complainant with a copy of the reasons for decisions by a review panel, as well as the reasons in case of dismissal of a complaint at the initial stage.
There's no further debate unless somebody is going to propose an amendment. I will take it to a vote. Yes. Yes.
It seemed like we had support for the idea of adding the caveats that Mr. Xavier had suggested. If those were provided in writing, could we return to this amendment? And
Return to this after if you want. Yeah, that's no problem.
okay.
Okay. NDP Amendment 3, Mr. Beckwith, if you want to introduce that.
Okay. This is more talking than I counted on. That Bill C9 in Clause 12 be amended by adding after line 27 on page 8 the following. If the review panel dismisses the complaint, it shall inform the complainant in writing of its decision and the reasons for it. So again, this is the same rationale as the previous amendment. So
Comments?
perhaps likewise we can return to it.
Yeah, I mean, with the same, I'm assuming the same caveat, I would be inclined to support. I see no reason why we wouldn't codify that with the caveat not to disclose personal or confidential information.
So without further debate here, I'll return to that later if you have a sub-amendment. Yeah, Mr. Moore?
Just in the interest of practicality.
Yes.
Before someone goes around drafting the caveat, if we knew what Mr. Fortin's intention was on the amended amendment, it might save someone time.
He's pretty excited that we want to know his opinion.
I rather save someone the time, just.
Je pense que j'ai pas compris. Could you repeat?
Just before we go to amending the amendment, whether you're inclined to support NDP 2 and NDP 3.
Thank you, Mr. Chairman. Yes, I was inclined to support both amendments. I'm even wondering about the caveat. I think that goes without saying, but I have no major objections. So if everybody agrees to pass NDP 2 and 3 with a caveat, I would be happy to do the same.
Merci.
That was good. As to NDP 4, I have a ruling. Yep, sorry. I've been just advised of a technical thing. I can go to the next clause, which is clause 13, but I can't kind of go to the next amendment now until we revert back to that. So I will go to clause, yes, Mr. Nunziger.
So, Mr. Chair, if we do go back to NDP Amendment 2,
Yes.
if that's what you're suggesting, then I do have language that I think may give us a bit of a.
Can you provide it in writing too, and you can read it out?
I have it in writing, but only in English. So I probably need to read it out for the record.
I think Mr. Baccarat has some as well.
It's faster.
I just give it to, yeah. Oh, then we're there. Okay. What I'll do is I'll just briefly suspend while our great staff here will get it translated and sent to you in real time. So we'll suspend for a minute. Okay, we'll resume, I believe, in a few seconds. You should all have in your P9s the sub-amendment to NDP, sub-amendments 2 for NDP Amendment 2, as well as for NDP Amendment 3, and it should be in both official languages. I think he's still sending it. I was a little eager in my
Okay.
announcement that it's been sent. Yeah, just give a few seconds. Have you been able to send it to the two witnesses? Or even show them a printed copy? Can you send it to the witnesses as well, in case they have to comment on it? And we'll send it to the two witnesses as well, Ms. Azmi and Mr. Xavier. Okay, I think everyone has it now. Any debate on sub-amendment, NDP Amendment 2 sub-amendment? We're good? Monsieur Fortin?
Ça vient tout juste d'arriver.
It has just arrived. I need a moment to read it.
Au niveau de la traduction, Monsieur le Président,
Regarding the translation, Mr. Chairman, rather than shall not include, I would prefer not to say n'inclut pas, which in my view is not the correct translation for shall not, which would be ne doivent pas.
I'll adhere to your advice on that.
Not a good translation.
Is the wording the same, or?
it's not that bad. But,
Sorry?
It says the reasons do not include.
It's a good one.
no.
So
And in
do
fact,
we
we're
want
doing a
to,
fantastic job.
because I don't want to amend the amendment, do we just want to agree that the wording in French shall be as Monsieur Fortin says? Anybody have any objection to that? No. Okay, so we'll just,
Juste pour confirmer, est-ce qu'on va avec...
Just to confirm, shall we go with ne doivent pas or ne devraient pas? It will be ne doivent pas because devrait is conditional. There's no conditional in English, which says shall, so we should not introduce a conditional in English where none exists in French where none exists in the English.
Just again, I think just on the in brackets 3, the other one in brackets 2, there is no in brackets 1. If that do you know what I'm saying? there's a 103 ABC, but so that first one needs to be in brackets 1 and then this one in brackets 2. Like subsection 1, subsection 2. There's no subsection 1 already. Are you following me? Okay.
If I may, section 94 would become 94.1, and then we're adding 2 and 3.
I'm on. Okay. Okay, so that becomes a 1. Okay,
Amendment?
I guess.
Okay,
I don't know.
so the sub-amendment to NDP Amendment 2 carries. Shall NDP 2 carry as amended? Yes. And similarly, the sub-amendment to NDP 3, shall it carry? Yes. And then shall NDP 3 as amended carry? Okay. Now, as to NDP 4, I have a ruling on that. Bill C9 amends the Judges Act by replacing the process through which the conduct of federally appointed judges is reviewed by the Canadian Judicial Council. The amendment seeks to add the Federal Court of Appeal as an additional level in the process of appealing decisions on the removal from the office of federally appointed of a federally appointed judge. As House of Commons Procedure and Practice, third edition, states on page 770, an amendment to a bill that was referred to a committee after second reading is out of order if it is beyond the scope and principle of the bill. It's in the opinion of the chair that the inclusion of the Federal Court of Appeal in the appeals process constitutes a new concept that is beyond the scope of the bill. Therefore, I rule the amendment inadmissible. Yes, Mr. Moore?
I don't think your rulings are debatable. I know we saw a recent ruling in public safety where a new amendment was added in that I was shocked was ruled in order. I'm actually really surprised. I think even reading your ruling that this is 100% within the mandate of the bill, and it doesn't expand any, bring in any new expansion of scope of the legislation, and I think it's completely in line with the streamlining of the process. So, with all due respect, I would have to challenge your ruling on inadmissibility, Mr. Chair.
So I let you speak, which was, but it's not a debatable thing, but you challenged the ruling, so we'll have a vote on the ruling of the chair. All those in okay, how does it word? All those in favor of the challenge? Yeah, all those in favor of the chair's ruling be sustained?
Just a point of clarification, point of order to the clerk.
Point of
So
order.
if we're voting yes on this, which means we accept the ruling of the chair, right?
Yes. So all those in favor of sustaining the ruling of the chair? 1. So the ruling carries. So you want a recorded vote? You've got Mr. Fortin and 5. We had a show of hands. I think we have 5 and 6. So, Mr. Fortin? Yeah. Okay. So the ruling is sustained. Now also, the vote on NDP 4 applies to NDP 5 as they are consequential. Also, if NDP 4 is moved, CPC 1 and its consequential amendment CPC 2 cannot be moved as they are identical to NDP 4 and 5. So I'm just letting the members note that. So NDP 4 is out now, right? I don't, okay.
So we now go to shall clause 12 carry as
CPC
amended.
1 and 2, so now shall clause 12, right?
As amended.
Okay. Shall clause 12 as amended carry? On division. Shall clause 13 carry? Shall clause 14 carry?
We?
Yes?
15 carry?
Yes?
And this one's already been ruled, NDP folks. Sorry?
That's,
Yeah, straight.
it's totally.
Shall clause 16 carry? Yes. Shall the title carry? Yes. Shall the bill, has it been amended? Yes. As amended, carry? Yes. Shall the chair report the bill as amended to the House? Shall the committee order a reprint of the bill as amended for the use of the House at report stage? Yes. We will now suspend for a few minutes to go in camera for a second review of the draft report on the government's obligations to the victims of crime.
Thank you.